Some more news in the Kelsey Fitzsimmons case. So if you are new to this case, we just did our first video on this last time, and it's a very unfortunate, kind of sickening ruling that just happened in the case, which is why we have to talk about it and cover it. And there's some more news regarding that ruling. So just to catch you up very quickly, in case you're not familiar with what happened with Kelsey Fitzsimmons was a North Andover police officer. And at some point, she had a child, and she went through terrible postpartum depression. At some point, her gun was taken away. She was put on leave, but it seems like she got better at a certain extent. And at some point, she was at some sort of bachelorette party when her fiance claimed that she was making some remarks that she was going to hurt the baby. And eventually, the police came over to her house and said, unfortunately, we have to take away your baby because we hear from the fiance that you're going to perhaps harm the baby. Well, she wasn't too thrilled about that, and this is where the stories kind of diverge. According to her, she pulled out a gun and held it to her own head and said, you're going to take away this baby, well, I'm going to end my life. And according to the police, she actually pointed the gun at them, which caused them to shoot her. So one of the police officers shot her. She did make a recovery, although she is still recovering from that bullet wound. As you can imagine, being shot by a bullet is not a pleasant experience. She was in the hospital for like over 50 days, and she is still suffering from the wounds. She was arraigned from her hospital bed, and at some point she was released on bond. Now, she had to have certain restrictions, which included house arrest and certain testing. One of the testing that she had to do was blow into this scram device. And this is a device where when you blow into it, it registers at the police station whether you've been drinking any alcohol. So as you can imagine, after being shot by a bullet and having broken ribs and who knows what else going on inside of her body, it was very difficult for her to blow into the scram machine. So her attorney, Tim Bradel, filed a motion to modify her bond restrictions and just figure out some other way to test for alcohol because, after all, she has some broken ribs and it's very difficult for her to blow into this machine. They had the probation officer who was completely helpful with this, and he was supporting this motion essentially because he said, yes, he saw this, that she would blow into the machine and she'd be in terrible pain and she'd be knocked out for the next couple hours. So he was kind of all for it. They had an email and there's some affidavits filed, and the judge, which we played in this last video, you can go check that out. It was posted by Jess Machado, by the way, the Jess Machado Show, if you want to see the entire or hear the entire hearing, what happened there. The judge said, well, it seems that she's not going to be able to be compliant with her release conditions, and therefore we are revoking her bond, and she has to be locked up. Okay, so if you go listen to that hearing, it's kind of sickening. Now, what happened is that Tim Bradel filed a motion for reconsideration. So this is just telling the judge, okay, maybe you had a bad day, maybe you were mad, maybe you're upset, maybe you didn't like me, Tim Bradel, the lawyer. Don't take it out on my client. Okay, and quite frankly, he's 100% right here. So let's just pull up his motion, and we'll talk about what could have been done instead of revoking her bond. So let's pull up this motion. This is the motion for reconsideration. Not too long, and here we go. As you can see, motion to reconsider imposition of custody and for reinstatement of original terms of release with order for alternative alcohol testing. Now comes Ms. Kelsey Fitzsimmons, defendant herein, and respectfully moves that this court reconsider its revocation of her release and instead impose available alternative alcohol testing by random urine tests as set forth in the attached email provided by probation. As grounds, therefore, the defendant respectfully states that returning her to prison is not the least restrictive alternative to effectuate the court's aims and concerns regarding alcohol testing. Instead, the court can order an alternative to the scram testing whereby the defendant submits random urine tests to the EverHealth contractors as set forth in the attached email from the probation department. Undersigned counsel has been informed by probation that there is a testing facility approximately 10 minutes from defendant's residence on Essex Street in Lawrence, where she can be driven as per the court's order to be tested in a random fashion. The random testing involves a probationer calling every morning to see if she is required to go to the facility for random testing. Her mother or father are available to transport her to that facility whenever the testing requirement is invoked. See email from probation department, etc. The court can accomplish its goals with this alternative rather than incarceration and without causing Ms. Fitzsimmons undue pain. Undersigned counsel has been informed by probation that this testing method is available in this case. Thus, the court may order a less restrictive alternative than incarceration that completely addresses the court's concern over alcohol use and the safety of the community and any person without the severe alternative of incarceration. Defendant presented to the court that attempting and completing the scram caused pain at the time as well as 3 to 4 hours thereafter. The court acknowledged she did not want the defendant to be tortured, but did not consider other alternatives that would accomplish the goal without pain to the defendant. The court's revocation of all the conditions set to send the defendant back to jail is worse by far than even requiring her to submit to the scram. Aside from her total loss of liberty, the defendant is a police officer and former corrections officer who would face serious risk of bodily harm in such a facility. Ms. Fitzsimmons is requesting an expeditious determination of this issue and does not request an in-person hearing. Defendant requests an expedited response from the Commonwealth reporting their position to the court, consistent with the case law, provided that relief in this type of case must be speedy if it is to be effective. Stack versus Boyle, and that is it. Conclusion. Okay, so therefore, that is Tim Bradle's motion for reconsideration of this judge's ruling. Now, let's just take a quick look at the statute here, because, statutes are important, especially they should be important to judges. When can a judge revoke a bond? So here we go. Take a look. This is the statute. It's 276, section 58B. And let's see, this is release on condition, revocation, and order of detention for violation, amending conditions of release. A person who has been released after a hearing pursuant to sections, etc., and who has violated a condition of his release. Now, let's stop right there for a moment. Who has violated a condition of his release shall be subject to a revocation of release and an order of detention. So some people were discussing online, well, did she actually violate her condition of release? Now, if you listen to the hearing, which is, again, very suggested to do if you're going to have an opinion on this matter, listen to the hearing, because in the hearing, you see clearly that she did not violate the condition of her release. So that's number one. First thing here hasn't even been found, that you have to violate the condition of release. Didn't happen here. The judicial officer shall enter an order of revocation and detention. If after a hearing, the judicial officer finds, number one, that there is probable cause to believe that the person has committed a federal or state crime, that didn't happen while on release, or clear and convincing evidence that the person has violated any other condition of release, and two, the judicial officer finds that there are no conditions of release that will reasonably assure the person will not pose a danger to the safety of any other person to the community, or the person is unlikely to abide by any condition or combination of conditions of release, then there can be reasons to revoke the order, right? Revoke and amend the conditions of release. So this is why Tim Bradle mentioned, and by the way, he should have quoted this statute. Okay, that's just one thing on him. Okay, he should have quoted it. But if you see this is clear that there has to be a violation of the condition, right? If after the hearing, the judicial officer finds, number one, that there is probable cause to believe that the person has committed federal state crime while on release, or clear and convincing evidence that the person has violated any other condition of release. So that's the first prong. You got to get past number one before you even get to number two. So let's ask the question, did Kelsey violate her condition of release? Go listen to the hearing before you state an opinion on this matter, and you'll see very clearly that everybody agreed that she did not violate her condition of release. The probation officer said that he would not consider what she did a violation of the condition of release. What did she do? So to remember what happened here, what she did was that she would try to blow on the machine. So let's say the testing came out. You got to test today at 12 p.m. So, okay, she got out the scram device and tried to test at 12 p.m. But sometimes, because of her immense pain, because she was shot and has broken ribs and who knows what else going on in her body, she was not able to complete the testing. So she tried the testing, was not able to complete it at 12 p.m., but this is the big but that a lot of people are forgetting about. She did eventually do it. So it's not like she tried, or some people don't even try, right? That's a clear violation. Here she tried at, let's say, 12 p.m., was not able to do it because of her immense pain, and then still summoned up the courage to try it again, and eventually did do it later. And the probation officer said, this is very common. This happens a lot, where you have somebody where we put out the test, hey, do this test at 12 p.m., and sometimes they don't even do it. They don't even attempt to do it at 12 p.m., but they do it at, let's say, 2 p.m. And they would not consider that a violation because they still did the test and they came out clean. It was fine. They passed the test. That's what happened here, to be very clear. So the probation officer said this would not even be considered a violation of her release. No conditions. She didn't violate and not comply. She was compliant. And therefore, Tim Bradel filed this motion, and the motion was filed by Tim. This wasn't like a motion that was filed by the probation officer that they would, if someone violates the release and they get involved and they file motions. No, this wasn't a motion that was requested by the Commonwealth that her release be revoked, that her bond be revoked, and that she be sent to jail. That wasn't what happened here. What happened here was that Tim Bradel just simply asked the court, can we modify her conditions of release? Can we have some sort of alternative for her to test? So that's number one. So we don't even get to satisfying the statute in this case that she should have her bond revoked. That's number one. Number two is that the judge said in her order that, first of all, she didn't, Bradel did not give any sort of alternatives. And that's not true. If you actually listen to the hearing, he did say there are other alternatives, including urine testing. You can do that. Now, he did say that, she is under house arrest, so you'd have to modify that part of the order as well. That is an alternative, though. Here's the alternative, Judge. It takes 10 minutes to drive her to the place. Let's say it takes her another 10 minutes to test and 10 minutes back, right? Okay, so that's a half hour. So, Judge, all we're asking for you to do is to modify your order, have it that she can go do these urine tests at random. And again, the judge said that she felt that the testing that she ordered was at random, although Tim Bradel didn't remember that. And again, I don't have the documents to show what her original order was. But even if it was random testing, well, then we can still accomplish that. Just modify the order, just a drop, that she'll be on house arrest for 24 hours and 30 minutes a day. And the other 30 minutes will be taking her parents will take her to the testing facility, do the urine test, and then bring her back. That's all he was asking for. And then the judge, on her own, said, I just don't think she's going to comply. So she's preemptively saying that I'm going to consider this a violation because I don't think you're going to comply. And since I don't think you're going to comply, I'm going to preemptively assume that you didn't comply, and therefore this statute will be applicable. That's not how this works. That's not anywhere in the statute, and I haven't seen any case law that suggests that you can do that either. So that's number one. Now, if the judge had any sort of compassion in this case, what the judge could have done is a number of different alternative measures. Let's say she said, sorry, it's going to be scram or nothing. Scram or nothing. Well, the first obvious thing that she could have done is said, okay, your motion's denied. No, you can't have alternative testing. You have to do the scram testing. Okay, fine. But she didn't violate it yet, so send her back home. And if she's just in too much pain to do the testing, to do the scram testing, then at that point, you can initiate proceedings to have her bail or bond revoked. That's what you can do. But there was no violation yet. So that would be the most obvious. You want to be a real jerk as the judge. You can say, sorry, no, I don't care how much pain she's in. She's a criminal defendant. She could be incarcerated. I was so generous to allow her out on bail and bond. So then, sorry, she's got to do the scram or nothing. Okay, fine. So let's do that. After all, she has been doing it, maybe not exactly at 12 p.m., but she did eventually get to it. So that's the first alternative that you can give. And the judge could have ruled. What are some other alternatives? Because one of the issues that the judge had here was that she said, well, you didn't submit any medical records. Well, first she had a problem with the affidavits and the emails, which she said, well, an email is hearsay. You can't even submit that as evidence in this hearing, which we also showed in the last video. That's not true either. In these type of hearings, you could submit even hearsay evidence. So that's like straight out in the statute also. Now, additionally, there was affidavits filed by her parents. And maybe she will say, yeah, I'm not going to give a lot of stock in the affidavits of her parents. Her parents are going to be on her side, so maybe I won't give a lot of stock into that. Okay, fine. But the probation officer himself got on the stand and testified that, yeah, he saw this. And he has no problem with modifying it in some way. She is in a lot of pain. Well, maybe I should change that. I'm not sure if he said that he'd be okay with it, but he did testify, maybe because that's the position that they can't agree to modify. But he was truthful, and he said that she is in a lot of pain doing this scram testing. So that was direct evidence of what she goes through when she tries to blow into the scram machine. Now, the judge can still say, well, I still need medical records because because I'm not going to take judicial notice. I mean, that's another option that she could have taken. She could have said, well, there's no one, it's not a point of contention in this case whether she was shot. Everybody agrees that she was shot in the chest and that she was in the hospital for 50 days. She was arraigned in the hospital bed. You remember that, Judge, shouldn't you? I mean, that's on video. You can see her in the hospital bed being arraigned. So no one here is disputing that she was shot. So she could take judicial notice that when someone is shot in the chest, there's probably a very reasonable conclusion that she's having trouble breathing into this machine, this scram machine. We have to blow into with certain force and with extended amount of time. And anyone who's broken a rib, even just broken a rib without being shot, can attest how difficult it is to breathe, even just regular breathing. Forget about blowing into a machine in an extended period of time. So judicial notice, she didn't want to take. The observations, the direct evidence of the probation officer, she didn't care for. The affidavits, maybe she didn't give stock to because they're her parents. Well, are there any other alternatives if you have a compassionate bone in your body? Well, yeah, there's also some other alternatives. What the judge could have said is, like we said, sorry, I'm not modifying it. You can do the scram, or you can't do the scram, and that's it. Okay. Or what the judge could have done, the judge could have said, well, let's have an evidentiary hearing. Let's have a hearing, call the doctors, and the doctors will say what her medical condition is. We'll hold it next week. We know in the Karen Reed case, there's multiple evidentiary hearings. We had Dr. Russell come in all the time, every other week, to come give testimony about what her opinions are. So go get a doctor from, Mass General Hospital, who treated her, and he'll come and testify whether she actually was shot and whether she has broken ribs and other problems with her body, other injuries that she suffered that makes it difficult. That's another option we could have done. We could have done that. Number two is what we could have done as a judge. You could have said, we're going to hold off ruling on this motion. In the meantime, you got to continue the scram. I'm very sorry. You got to continue with the scram device every day. We're going to hold off ruling on this motion until Bradel will submit supplemental pleadings, which he'll have supplemental attachments of the medical records. So go get the medical records and submit them. And then, okay, now I'll consider them. That's another option that she could have done. She could have had also an evidentiary hearing, because part of the issues here is that she said that we don't know if she's a danger. She may be a danger to the community. She may be a danger to Officer Noonan, who shot her, right? Because he shot her. So maybe, if she was pointing the gun at him, right, according to his story. And again, let's not forget that there is a presumption of innocence here. That didn't go away just because she is a criminal defendant and they met the very, very low bar of a probable cause, which, by the way, the grand jury only indicted her on assault with a dangerous weapon, not attempted murder. So she still has a presumption of innocence as she sits in front of you, Judge. So you're not just to believe, automatically assume that Officer Noonan's story is correct. But let's say you are concerned for Officer Noonan's safety and the safety of the community. Number one, you can look at her criminal record for the safety of the community. Let's see if she has any other violent offenses, what her criminal record is. Probably doesn't have one, but we could do that. And then also you can call Officer Noonan to the stand. Say, Officer Noonan, I don't know how tall he is. But I don't know. Let's say 6'2". Let's say 6 feet. Let's say 5'10". Whatever. He's a police officer. Officer Noonan, how concerned are you for your safety when if we were to release Kelsey Fitzsimmons with a bullet hole in her and broken ribs? How concerned for safety would you be? Have him on the stand and ask him those questions, point blank. Are you concerned for your safety? Are you scared? Are you nervous? She might do something to you. Is she afraid she's going to come after you? Is that what you're nervous about? So if you're so concerned for the safety of the community and for the safety of Officer Noonan, well, then call him onto the stand and look at her criminal record. And then you can make a determination there. So there are multiple alternatives that could have been thought about before just locking her up. Definitely the urine test is a reasonable alternative as well. But we don't have to get there. Like, there's so many other alternatives that could have been done in this case that weren't. So now we have this motion for reconsideration, and based on the statute, which we just pulled up, you can't even revoke it. There's no basis in the law to revoke her bond because she was not in violation. There's no material changes in the circumstances. It's another one. If there's a material change in circumstances, or she violated a law, maybe she broke a law. If she broke a law, then yeah, like what they tried to do with Karen Reed, right? If we can figure out some other felony or state crime that you committed while you're out on bond, well, then we can lock you up. We can revoke your bond. That didn't happen. So many different options that could have been done. And here we have Tim Bradel filing this motion for reconsideration. And what the judge should do is the judge should do the right thing. Just listen to that hearing, and it seems like there's just some sort of issue that she has. Like, what's the issue? Calm down. You have someone who was shot. You have someone who's obviously suffering from a lot of injuries. Maybe you don't like Tim Bradel. That may be true. Maybe she doesn't like Tim Bradel. That's fine. Why would you take it out on her? Take it out on me. Scream at me. Admonish me on the record. That's attorneys get that. You're sticking up for your client. So admonish me. Say that you have a problem with me. That's fine. But why are you taking it on my client when she didn't do anything wrong? So that is where we stand right now. Hopefully the judge will do the right thing and reconsider her order. And there's some problems with her order, which we went through in the last video. But that is the right thing to do. And hopefully she will get it right this time. So that's going to be it for the Kelsey Fitzsimmons update. We'll continue to monitor the case and see what else is going on. If anything happens, we'll let you know about it and break it down and do some legal research and legal analysis and catch you all up. So that's going to be it for Kelsey Fitzsimmons. If you haven't yet, please subscribe and like, and we will see you next time.